Hello, hello, and happy Monday, everybody. I hope that you all are well. I am excited to share with you today that I have a special guest. She is no stranger. We're talking about Fair Housing Month. The entire month of April is National Fair Housing Month. And so I have with me today Miss Abby Volin, and she is an expert on this subject matter. So, Abby, let me have you to do an introduction of who you are. Tell the people a little bit about you.
Well, Karissa, thank you for having me here this evening. I'm so excited to speak with everyone. My name is Abby Volin. I am an attorney advisor for the DC Office of Disability Rights. Now, first thing I have to say is I am not providing anyone with legal advice. This is just information. So keep that in mind. So I've been doing this work now for the past 6 years, been focusing on fair housing, and my very specific niche actually has to do with service and assistance animals. And I know that the animal issue is a big one with housing providers and communities. So I'm here to answer whatever questions you may have about that.
Great. Thank you so much. I just want to give a shout out to some of our viewers. We have Kimberly Parker. She's tuned in from South Carolina. We have Sissy. She's tuning in from Brooklyn, New York. So, Abby, we have a wide range of jurisdictions that watch. And so today we are covering information specifically for DC, but please be aware and know that fair housing laws, they're in place. And they are to protect tenants. And so today, Abby, as you know, we're going to discuss the subject matter, and we do have some questions that have come up. And ladies and gentlemen, friends, colleagues, family members, if you have questions pertaining to the subject matter today, please go ahead, drop it in the comment section. We do have viewers who are tuning in from Facebook as well as YouTube. Hello, Lynette, thank you for tuning in from North Carolina. We have Deborah, who is tuning in from Los Angeles, California. Thank you so much. All right, so Abby, this subject matter is near and dear to me because I've had so many colleagues of mine and clients asking about whether or not they have to allow their tenants to have animals and dogs and things of that nature. And because this subject matter is so near and dear to me, just recently I took a fair housing course to become a national fair housing specialist, because this is something that I believe that a lot of people, a lot of housing providers, as well as tenants, they are not aware of rights and responsibilities. And so today, Abby, we do have some questions that have come in, and I'm going to bring those up on the screen. But I just want to give your information out to the viewers so they'll know who you are, how to get in contact with you rather. So let me put your information on the screen. And Abby, we can start wherever you like before we get into the questions.
Sure. So one thing I want to mention, I think it's wonderful that you have such a wide audience from all over the country. The federal laws, so we're talking about the Americans with Disabilities Act, the Fair Housing Act, the Rehabilitation Act. These serve as a floor, not a ceiling. So what I mean by that is that all states must adhere to the federal standard. And if a state can have, states and cities, they can have laws that provide more protections for individuals living with disabilities, but they cannot provide fewer. And that really comes into play with a lot of these state laws that are trying to, reduce the fraudulent use. Like a lot of times those actually conflict with the Fair Housing Act. And so a housing provider that would follow the state law would be in violation of the federal law. But this is all to say that the information we're talking about tonight, it's widely applicable. It's going to apply to everyone. One thing I like to stress is that housing providers have rights. You have rights when it comes to these animal accommodation requests, and you should absolutely assert them. I call it animal accommodation request, but frankly, it's no different than any other type of reasonable accommodation request. And I think that's really important to keep in mind. It's not like you have a higher standard of burden of proof to establish you're living with a disability or you have a related need. one way to kind of test out your own policy is, replace the word animal with wheelchair and tell me, does it sound ridiculous now? And if it does, then you probably can't ask it for somebody who's making a request for a service or assistance animal either. The difference being that, we don't have nearly as many people asking for, ramps for wheelchair access as we do for service and assistance animals for those requests. And I know how confusing they would be. So I'm just going to start right now with some definitions, a little bit of language, and then I'm happy to jump into your questions. So we all know the term emotional support animal. I hate that term. I absolutely hate it. So assistance animals are not pets, right? So you have service animals, which are allowed in places of public accommodation. They're allowed in public spaces under the ADA, and they can only be dogs, and they must be trained to perform a specific task for the individual with a disability. So service animals, service dogs, they're allowed in public spaces. They're also allowed in dwellings. And Fair Housing Act, it applies to most dwellings, actually very, very limited exceptions. So pretty much you can assume that you have to comply with fair housing laws. Assistance animals, they provide assistance support. They do tasks for individuals living with disability, or they provide emotional support. They don't need to be trained. They have to be, there's actually new laws now, new regulations around this. And HUD has said, no, you can't have your emotional support boa constrictor. It has to be a species that's commonly kept as a pet, which makes a lot of sense. If you need an exception to that, then, again, these are called reasonable accommodations for a reason. They have to be reasonable. All right, so we have service animals and then we have assistance animals. Emotional support animals are one type of assistance animals, but animals can help us with so many more, really limitless types of disabilities, types of impairments. And so I don't even know what emotional support animal is. We don't call it emotional support medication or emotional support doctors or emotional support therapy, right? Like, it's become a stigmatizing and a joke and a punchline. So assistance animals, it's also limiting, right? Like you can, if I have a dog that can detect when I'm about to have a seizure, but he's not trained to do it, that's an assistance animal. He can't go with me in public because he's not trained. But that's certainly not, for mental health purposes, for which, that is a very real thing too. I want us to understand that there is a much bigger universe of impairments for which animals can help us. So for assistance animals, it has to be a species that's commonly used as a pet, commonly kept as a pet. You can't, they're not pets. So when you have no pet rules or breed, weight, size restrictions or fees, none of that can be applied to a service or assistance animal. Again, replace it with wheelchair. And you're not going to charge someone for bringing a wheelchair in and a monthly rent for having their wheelchair. So they're not pets. You can't apply pet rules. However, they still do need to be good neighbors. The animals still need to be behaved, under control. They cannot pose a direct threat to the health and safety of others. And this includes stereotypes, right? You can't say, well, I'm afraid of pit bulls. Pit bulls have a bad rap, so we're not going to allow pit bulls. It doesn't work that way. It has to be, does this specific animal pose a direct threat to the health and safety of the community that cannot otherwise be mitigated? But if you have a tenant who has a dog that's out of control, or a cat that keeps, spraying on the walls, peeing on the walls, and the odor just emanates in the hall and they're not getting rid of it. If it's a nuisance issue, if it's a threat issue, if it's a significant likelihood of damage that can't be mitigated, you can deny the request or you can rescind it. Once you give the resident notice and say, give them a warning or two, and let them know that if they don't fix this, if they don't cure, their animal is going to be asked to leave. They're not going to be able to keep their animal. And so you can do that. So the other thing I want to mention is with verification letters. So verification, and that's an important issue too. When you have a service animal, you could ask 2 questions. Do you need this animal because of a disability, and what is the animal trained to do? But you can't say, okay, so now make Fido, fetch your medicine or whatever it is, right? You have to take it on their word. With assistance animals, so this is when the disability or related need is not obvious, you can ask for reliable verification establishing the disability and related need. It actually doesn't need to come from a healthcare provider. It often does, but that's not a requirement. The definition of disability is incredibly broad under disability rights laws, under civil rights laws. It is when you have an impairment that makes it more difficult for you to perform a daily task of active living than the average person. Really broad. It is not a high hurdle to jump. Do you have an impairment that makes it more difficult for you to perform a task than the average person? And that's it. And it actually does not take, it's not supposed to be an extensive inquiry. It doesn't take scientific or medical or statistical analysis to do. So this idea that people are making these requests who don't have a disability, it's because of just not understanding how broad this definition is. So verification, so they have to establish that they're living with a disability and that they have a related need, meaning the animal does something that alleviates a symptom or effect of the disability. And the reason I'm getting into verification letters because there's so much misinformation about these laws and guidance that I can't tell you how many letters I see that are actually legally insufficient. And housing providers just accept them anyway because they've been told you don't want to mess with that. You don't want to risk getting dinged with a violation, a fair housing violation. What you're supposed to do if it's insufficient, you go back to the individual. You don't contact the doctor. You go back to the individual and you say, I need more information regarding X. And, it has to be in good faith, not just to delay the process. I need more reliable information on this aspect. Here's why, when I tried to call the person who wrote the letter, the number was out. Something like that. So, and I say don't contact the letter writer. You can contact them to authenticate the letter, right? Did you write this? Is that your signature? And maybe even I have to think how to phrase this. But basically what was the type of interaction you had with the individual, right? And what I'm getting at is in person, fine. Phone call, fine. I found this service and I took an online quiz and I answered every question in the negative. Do you miss your pet when you're away? No. I answered every question like that. Took 3 minutes and then they said, you're qualified. So, something like that, I think it would be okay you wouldn't be able to say is this your patient? Or, what did you say? But to say what was the framework for the information? The individual just needs to have personal knowledge of the facts. So I see a lot of letters that simply, they don't give all the necessary information. You don't have to reveal a diagnosis. You should be broad to the diagnosis or broad to the impairment, but specific when it comes to the symptoms and how the animal will alleviate them. And so you just have to be really careful about the type of information you're asking for. And a lot of times residents will just have all the information because they think the more you have, the more the easier it will be for approving the request. But that's also personal, private health information that people shouldn't have to reveal. So if you don't have reliable verification, don't just automatically approve the letter, because here's what's happening. when you engage in the interactive process and you say, I don't have reliable information, can you please provide me on X? The resident doesn't come back with any information. And you don't have to approve a request if you don't have all the elements. And if it's the resident who goes radio silent, that's fine, right? You can just, it's open. You have the communication, the back and forth, and now it's just up to the resident to continue. So here's a common issue I'll see. Someone will say like, I have diagnosed this person with X, and they need their 4 cats to serve as their emotional support animals. Well, it doesn't work that way. When you have, you can have 4 assistance animals, but each would need to be separately justified. So maybe you have, 3 kids and each kid has their own, or, the cat will do one thing to alleviate a symptom and the dog will do another. You just have to have that justification. And most people don't. Even, when telling them this, like they just don't have that. I also don't like this idea that people think people are afraid of fraud if you speak with someone for one time and they give you a letter with approving you. It doesn't. You can go to a doctor and get diagnosed with something on the first visit, right? And we're not even looking it doesn't even have to rise to the level of a diagnosis. It's actually a lower standard than that. So this idea that you can speak with someone on the phone, you can have a telehealth session, you can someone else who would be, I think, a reliable person to write a verification letter. Let's say you are in AA and your dog has been the only thing keeping you sober. If the peer group leader for that group is willing to write a letter saying, they through personal knowledge, you've been going here and they don't have to say what your disability is, but here are the symptoms. And, I've heard how his dog helps him get out of bed in the morning, and he has to, keep a schedule, and keep the dog fed and, keep his presence of mind. And that's reliable, right? Like that's a reliable source for a verification letter. So like everything, it's just case by case basis. You have to evaluate this. And I know I just threw a ton of information out there. So let's get to some questions.
All right. So let me get to the questions. If you have questions or comments, go ahead and drop it in the comment box. I'm going to Kim Parker first. Her question is, what do we do when we have an indoor event and someone has a service animal and some people are afraid of dogs or cats? Great question, Kim.
That is a great question. The same thing goes for allergies. One disability does not trump another. And in this case, someone is afraid of an animal that doesn't necessarily rise to the level of an impairment. Do they need a reasonable accommodation? When it comes to situations like that, it's best to just be upfront with everyone and ask for people to be considerate, right? Like somebody who has a service animal, their dog should be on a leash at all times when they're outside the unit, unless their disability does not allow them to do so, but then, under voice control. So if somebody is afraid of animals or has allergies, they're just going to have to avoid each other. And the person with the service animal, they are going to also, they should be considerate of other people in the building.
Okay, we're going to go to our next question or comment rather. This is from Pete. He's tuned in from Baltimore. And Pete, you said training for service dogs require extensive 2+ years of training. Is that a question or a comment? Pete?
Doesn't matter. So that's a great statement. I'm so glad you brought that up, because under the law, there are no training standards on purpose, because we want this to be accessible, right? And not everybody can afford thousands upon thousands of dollars of professional training. Now, sometimes it might be necessary depending on the task that you need to train the dog for. You can train your own service animal. And you don't need any kind of certification or registration or anything like that. And all of that is meaningless. Now, there's certainly, like Guide Dog for the Blind, there absolutely are companies that will, train a dog to do very specific tasks, and it takes a lot of money and time and energy to do this. And then they'll give you a certificate this animal is certified as, and that is legit. It just doesn't mean anything in a legal sense. It's just for your knowledge so that this dog has been through XYZ training. Mm-hmm. But training for a service animal, it needs to be accessible. And to be accessible, it means you can train your own service animal. I will say the one thing we have in DC that is not universal across the country is that we allow service animals in training to access places where service animals can, which makes sense, right? Like if you're going to train them for being out in public and interacting, you have to, actually physically have them in those spaces. And there are quite a few states that allow access for service animals and training. But regardless, service animals, they must be trained, but there are no standards for how they're trained or who trains them.
Okay, that's a good point. Thank you for that. Hello, Michelle. Hello, Dr. Baker. Thank you so much for tuning in. Abby, we're going to go to our next question, which is coming in from Nicola. Here's her question here. She's asking, what happens if the letter is one of those that you get online with the 3-minute questionnaire? Great question.
Great question. And here's how we combat fraud. Frankly, the people taking those quizzes aren't committing the fraud. It's the it's the company that's spitting out the letter. And fraud is like, it doesn't exist. It just does not exist. I know everyone thinks it exists, but that's like anecdotal and gut feeling. When you look at the data, it simply does not exist. So if you do come across a letter that's not reliable, whether or not it's from a 3-minute survey or it just doesn't have all the information you need, that's when you engage in the interactive process. And you go back to the resident and you say, I have concerns about, it's missing X, or I have concerns about the reliability of this because it was just a 3-minute survey, and that's not going to rise to the standard to establish, even this very low standard of what a disability is. So the best way to combat bad requests is to assert your rights and insist on having all the required information before you grant these requests. Now, you should, HUD suggests that you get back to tenants within 10 days. I'm not even sure if it's business days or not, but 10 days. But that could be, getting back to them in 10 days could be, I wasn't able to get a hold of the provider. Can you please send me another letter? And actually with the one that I did online, I called them up to, pretend that I was a housing provider verifying the letter. The number didn't work. I couldn't get a hold of him. I couldn't find him online. And then when I complained to the company, they said, well, our letters comply with federal law, so you should file a complaint with HUD against your landlord, which that's not right. And they said, well, because of HIPAA, we can't divulge it. It was just crazy. If you can't get a hold of the individual who wrote the letter, it is not reliable. You are allowed to authenticate the letter.
That's a good point. Thank you, Abby. We have another question that's come in from Lauren. Her question is, wait, I can't charge a pet fee?
No, not for service or assistance animals. Can you charge an access fee for a wheelchair? Nope.
Good question. And that was one of the frequently asked questions, because a lot of housing providers, they want to know if they could charge a pet fee, a monthly pet fee, pet deposit.
For a pet. But remember, these are not pets.
Right. So I have a question. I just got a text message, someone that's viewing from YouTube, but they asked if they have a tenant who wants as an emotional support animal. They want a guinea pig, but it's a large pig. It's a large animal. It's not like it's a guinea pig. And so they originally told the tenant no, that they couldn't, but now they're questioning, are they required to accept the guinea pig as a tenant's emotional support animal?
What's wrong with the guinea pig? It was big.
I'm assuming that it was
Okay.
big.
Yeah. Guinea pig. I mean, the HUD has guidance memo on this. And they list out, like, here are the species that are commonly kept as pets, and yeah, small rodents, guinea pigs, yes, those are allowed to be assistance animals. So I would revisit that request.
Okay. And here's another question that came in. Someone want to know, can they legally refuse the animal and not be sued?
I mean, that's going to depend. So I guess you're saying, like, you've gone through all the steps, they don't provide the reliable information, or it's established that they're not living with a disability, or the resident just goes radio silent. And so or the animal is posing a threat to the community, right? And so now you want to kick the animal out. If you've gone through all the steps, have a checklist, go through the steps, you are allowed to deny requests or rescind them. So, policy and process will save you, right? Have a policy in place, have a protocol in place. And so that way, if you're ever investigated, you could say, but here's what we do. And you can show that as, like, here's your practice. Here's how you handle such situations. And, that can help establish that you are in compliance. Document everything, right? Document whatever interactions you're having. Again, so you have that record that you did everything right.
And that's that's so true, Abby. One of the things that I share often is that housing providers should document, because it's not what you know, it's what you can prove. But to always document the interaction, the conversation, because sometimes people just may not remember, right? And if it has to go any further than that, that documentation is going to be so important. We do have another question from Denise Lancaster. She's asking, she says, I have severe allergies to dogs and cats. Can I refuse because of my health?
So that makes me think, well, one, if you're living with the individual, if the individual's living with you, depending on how many units, right? Basically, if it's your personal home that you're renting out rooms, you may not be obliged to adhere to the Fair Housing Act. You'd have to look at your state. So, but so if I am renting out a room to someone and I have a terrible allergy, and all the other provisions around me fit so that I'm not subject to the Fair Housing Act, nope, I don't have to allow that pet, or that animal, not pet. But if you are covered by the Fair Housing Act, or the state, the parallel state law, again, one disability does not trump another. So you have to find ways to make them both work. It could mean filters. It could mean, and you can't say, well, the animal has to use the back entrance only. It's just, these are all case by case situations, and you have to dance around it. And, maybe in if it's a multifamily building, you can reserve a couple washers and dryers for like, these are allergy sensitive. Only if there are no pet hairs at all on you can you be using, these two washers and dryers, HEPA filters. There are ways to try to work around it, and make everyone happy. And there are situations where you can't. And again, it gets muddy. There is no clear advice in those situations other than document. Don't favor one over the other. There really is no bright line rule. Document what you're doing to try to accommodate everyone. And you can always call, like, a local fair housing association and ask them for advice on how to accommodate.
Okay, thank you for that. We have another question from Lauren. Lauren is asking, if you require insurance but tenant cannot obtain or maintain because service animal is considered dangerous or insurable, i.e. a snake or pit bull. How do you handle that situation?
Great question. So, so these are called reasonable accommodations. They have to be reasonable. A reason that it would be unreasonable is if it is a significant financial or administrative burden, right? So if your insurance rates are just going to go through the roof because of this animal on your property, well, then it's not reasonable, and you can say no. However, you are going to have to establish that you have looked for other comparable insurance and haven't been able to find anything. And that, like, these exceptions just, they don't really happen because there are enough insurers out there who do insure all types of dogs. And I mean, if it's a snake, I don't think that's a common household pet, but maybe that's just me. But the insurance companies, they can get in trouble if they are systematically not insuring service and assistance animals of, certain breeds without an individualized risk assessment. So that financial burden, just it's going to be really difficult to establish. Administrative burden, it means that they're pretty much are asking you to, they're changing the nature of your services. So if you're a housing provider and they say, okay, well, I need, reasonable accommodation for my service animal, and I need you to walk them 3 times a day. And you can say, well, I provide you with housing. I am not a dog walker. So no, I'm not going to providing you a service of walking your service animal.
All right. Thank you for that. And Abby, those are all the questions that we have for today. Let me just share your information again so that housing providers in the DC metropolitan area will know where to find you and how to find you. So this is Abby's information here. She is with the DC Office of Disability Rights. That is her contact email address and telephone number. Abby, it was such a pleasure to have you today. I'm so excited that we were able to connect and get you on to share this information. As you've seen with the questions that have come in, housing providers, they are concerned. They're asking questions because they want to be in compliance and they want to know, what the law says they can and cannot do. And so I'm sure that you're going to get some follow-ups because I do have viewers who are going to watch the replay and we'll be reaching out to you. So thank you so much. Thank you, everybody, for tuning in today. Please make sure that you're tuning in each and every Monday right here at 7:30 p.m., whether you're on Facebook or YouTube. If you are on YouTube, please go ahead and click that subscribe button. And just by way of announcements, I have been announcing that in the month of May, for those of you who have purchased this book, Inspired Life, we're going to do a 7-day challenge starting May 3rd. This is a copy of my book, which is found on Amazon. It's called An Inspired Life. So if you want a copy of the book, go ahead and go to Amazon, pick up your copy. And if you can't remember the name of the book, just put in my name in the search bar, Karissa Spann, it will pull up the book. And so after the 7-day challenge, I'm going to select a couple of people. So the prize would be a $100 giveaway. So it's just a challenge, a 7-day journaling challenge where we're going to get into the book. We're going to discuss it. We're going to write. All right. So I do thank you for your time. Abby, again, thank you so much.
Thank you for having me.
Absolutely. So guys, our time is up and we thank you for yours. And I hope that you can join me right here next Monday at 7:30 p.m. Please share this information because sharing is caring. Mm-hmm. So Abby, just stay online. We're going to chat a little bit. And so guys, we'll see you all next Monday at 7:30 p.m.